I pledge allegiance
to the United States and to the
visible and justice.
Kate, will you call the roll, please?
Certainly. Don Williams?
Here.
Sean Kidd?
Here.
Eric Fearborn is excused. Doug Bryson?
Here.
Patrick Evans?
Here. Are there any agenda changes or revisions? Nope. Request approval of the minutes of February 19th, 2013.
So moved. Second.
All those in favor?
Aye.
Are there any members of the public who wish to comment on non-agenda items or matters not involving a public hearing?
No one has signed up to speak.
All right. Are there any final orders, resolutions, or written communications? And none scheduled?
No.
All right. I'd like to open the public hearing on the Bernier Family LLC, file APP 2012-02. This is an appeal of an administrative decision of the Planning and Community Development Director denying permission to rebuild a damaged non-conforming sign on an undeveloped lot. Subject property located on North Highway 101 near the Ryan Gallery on Assessor's Map 07-11-02BD, Tax Lot 700, in the General Commercial Zone. The appellant and property owner is Bernier Family LLC, represented by Mr. Ty K. Wyman. The public hearing for this matter was opened on February 5th. The appellant requested that the record be held open for 7 days to allow submission of additional evidence. The record was held open and the public hearing closed. On February 19th, the Planning Commission received the additional evidence as well as a city response. The appellant requested an opportunity to provide rebuttal to the city's response. The Planning Commission reopened the record to accept the additional testimony and the city response, and allowed 10 days for submission of rebuttal evidence, which has been included in the meeting packet. Mr. Apicella, will you please give us direction on the next step in this proceeding?
Okay, as you noted, the public hearing on this matter closed and the record is closed. It now comes back to the Commission for deliberation. One preliminary matter you probably need to get out of the way is, because this is still a quasi-judicial matter, since the last time you heard it, if anyone has had any ex parte communications, you need to disclose them now. If no one's had any, then you don't need to disclose them. But, Mr. Chairman, I'd ask that if anyone's had any additional ex parte communication, I don't believe you had any last time, but you would disclose them now.
All right. Have any members of the Planning Commission had any ex parte contact since the meeting on February 19th?
No. At this point, then, in the proceeding, you would deliberate, and you can ask your staff and legal counsel questions, not about new facts. I can't give you any facts that are not already in the record. We can talk about the law, we can talk about the facts in the record, and we can talk about the application of the facts in the record to the applicable law. I'd remind you, as a quasi-judicial proceeding, you are constrained to apply the applicable criteria to this decision. The criteria are set forth in the staff report, and they were included in the notice. Essentially, we're dealing with one chapter of the code having to deal with nonconformities in Chapter 1772, I believe. The specific sections that were implicated were the definition sections in 030, the prohibited sections in 050, the nonconformities article in 090, A, B, and C, and I believe the other provisions might have, oh, 060, special conditions and safeguards. I can walk you through the decision if you'd like. I can just get you. It's up to you. I generally am kind of hands-on, so I'm not shy. I'll talk to you about what I believe the applicable criteria are and whether or not they've been met.
Speaking for myself, I'd like you to go ahead and do that. Rest of the commission.
I'm fine with that, yeah.
Okay. Again, I'm not going to talk about things that are not in the record. So, and you yourself should not, and starting to deliberate, talk about things that are not in the record. So if you remember an example of something that maybe happened a couple planning commission meetings ago and you want to start talking about it, you probably should stop, because we only need to talk about what's in this record. In this case, you have a property that has general commercial zoning. You have a property that, and I think this is pretty much undisputed, is in an undeveloped state, as per the definition of undeveloped, which is set forth in the code. There is an existing sign which, according to the findings, originally was constructed pursuant to an ODOT permit in 1964, and that was in the record. There is also evidence in the record that this sign was expanded from the original permitted 250 square foot to its 314 square foot size. You also have in the record evidence that there was reconstruction of this sign in the 90s, and that staff had looked and found no evidence of any permits being issued to authorize that construction, or for that matter, the expansion to 314. The evidence also indicates that, in terms of background, that a sign basically was destroyed by a tree falling on it. There was some testimony at the hearing that the posts were rotting. I believe that was one of the applicant's witnesses, and that the construction was initiated without permits. A stop work order was placed, and that the request was then made to the planning director to issue the permit, which was denied. The planning director's report is in the record. The planning director's report talks about the fact that this is a nonconformity. A nonconforming sign is defined as one that lawfully existed prior to the effective date of the ordinance and is no longer in compliance with the height, area, or other provisions of the title. The staff report that you received really calls out two very key nonconformities. One is as regards the use, and one is as regards the size and dimension of the sign. So the nonconformance or noncompliance with the current regulations are, one, and this is in the staff report, the use a sign on an undeveloped lot is not permitted in the GC zone when the lot is undeveloped. So that's a use nonconformity. And then, and that is specifically in Chapter 17, 72, 050G. And then the second nonconformity in terms of noncompliance with the current regulations, the major one, is that if it was on a developed lot, it would be limited in size to the frontage. And there's a formula there, but basically with 50 feet of frontage, the maximum size of the sign would be 50 square feet, and in this case, the sign is more than 6 times that. So again, those are identified as the two major non-compliances with current regulations in the staff report. So the sign does not comply with those. But to be a nonconformity, you must have been lawfully established, not just be not in compliance with current regulations. So that part of the analysis is that, and again, this is from the definition of nonconformity. It says lawfully exists prior to the effective date of this ordinance. That means that it was constructed in accordance with regulations in effect at the time. There is evidence in the record that the 1964, the original construction of the 250 square foot was pursuant to a state permit. However, there is also evidence in the record that there is no record of a permit for the expansion to 314 square feet, and there is no record regarding permits for the reconstruction which occurred in the 90s. So in deciding whether or not this, to analyze this in accordance with the code, the first question is it a legal nonconforming use or is it an illegal use? And I would submit that you could find, based upon the evidence in the record, that you can't identify where the permit is that establishes this sign to be in its current configuration. That is, it's currently 314 square feet. They can find a permit from 1964 where it was given a permit to be 250 square feet. Anything after that, including apparent complete reconstruction in the 90s, is not documented. So that would be the first threshold issue. Is it a legal nonconformity? And if you find it's a legal nonconformity, then you would go to the next question, which is, does it qualify for repair under 090? So let's assume, for the sake of argument, that you believe this is a legal nonconformity. We can certainly tell from the evidence presented that it does not comply with current regulations. What is a decision for you to make is whether or not you believe that it's been established that this was legally authorized in the first place. But 090 says if you have a nonconforming sign, you can, number one, under subsection A, you can repair the sign, and that repair is limited in that you cannot affect any structural alterations. Subsection B basically says signs basically can't be moved, replaced, or structurally altered unless you bring them in compliance with current regulations. And again, this particular lot is a use noncompliance in that you can't have a sign without development, and this is not a developed lot. And then subsection C, which got a lot of discussion during your hearing, where the cost of repair of a nonconforming sign exceeds 50% of the cost of replacement of the sign with a conforming sign, the sign must be brought into compliance. So the test, as set forth in the code for limited repair, is that if the cost of the repair exceeds more than 50% of the cost of a conforming sign. And if in your staff report there is an example set forth by the director, and where he says, let's assume a conforming sign cost $1,000, repair would then be limited to $500, 50% of that. In this case, there was a different interpretation of this section proffered by the applicant. That is, you simply look at the value of the sign, which they asserted to be $50,000, and then look at the cost of repair, which they asserted to be a few $1,000s. And that, since that was such a small percentage of the value of the sign, it should be allowed. I would suggest that's not what the Nonconformities Article 1772-090C says. It clearly says that you compare the cost of repair against the cost of a conforming sign. And the director testified that you can't have a conforming sign on the site, therefore that cost would be zero. So any repair cost would exceed zero. Essentially, even if you take out the fact that the sign is prohibited because the lot is undeveloped, you then would have, back to his example in his staff report, some cost of a conforming sign, which, as we know, could not exceed 50 square feet, versus the cost of repair of a 300 square foot sign. So I don't think it's necessary to go there, but had you not actually had the use nonconformity, you would have a number for however much 50 square foot sign costs versus the cost of repair. And then the cost of repair could not exceed 50%. So that's essentially the key points. I think the threshold question is, do you believe that it has been established that this is a legal nonconformity? Was there evidence to your satisfaction that it was legally established? And then if you believe it was legally established, or even if you don't and you just want to go on and make these findings, does 090A repair authorize anything beyond replacing of a part, which is what it says? Again, the staff had asserted that it says structural alteration is not permitted. And then subsections B require, and C both require conformance with current regulations in the event those two sections are triggered. And when replacement is triggered, compliance with the regulations is required. When repair exceeds 50% of the cost of a conforming sign, conformance with the regulations is required. And since this property could not comply because its use prohibited, there's non-compliance with the criterion, and staff has recommended denial as part of course, that was the initial decision. This is a de novo decision, so you don't really owe any deference to the prior decision by the director, but obviously he's got a substantial amount of evidence in the record which you need to consider.
Thank you very much. Any questions?
Richard's not here. Deborah, I'll ask you, who owns the property again where the trees actually fell from? You know?
If it's not in the record, we can't
It may
answer.
be in the record. I'm not sure. That's my whole point. I don't have. I think that was the very first night we.
I can check the staff report
Okay.
and see what it says there.
I know that the original, in the record, the application for the tree removal for 5 trees, in which 3 trees were permitted, was made by the gallery.
Okay.
To me, pretty well covered we have before us, and one of the ones that strikes me most interesting is the and no permits were issued for that new site. A mistake that period of time. But there's those pretty.
Oh, Mr. Chairman, I with your indulgence, I did have one other point I didn't mention. There was some evidence submitted, and then the record was left open, and the record was reopened to address an issue about who exactly told which trees they could cut down. And I would submit that the relevance of that evidence is questionable. Obviously, there is no criterion in the code that says you can grant approval of development that does not comply with the use restrictions of the code or the size and dimension criteria of the code because someone felt that had a tree been permitted to be cut down, that somehow that would have avoided the destruction of the sign in question. Frankly, it's simply not relevant. So that's why I didn't really mention it, but I know that you had a great deal of information about that, but there's no criterion to which it goes to.
Thank you. Mr. Kidd, any further questions?
No.
Yes. Anyone?
I just will answer Sean's question about on what property. In the staff report, it just simply says a tree fell on the sign. I do have the PowerPoint that Richard showed in the first hearing, so if we, I can take a second and find the map that shows the tree. Okay.
That's
All right.
I'm all right with it.
All right. Any further discussion?
Yeah, I mean, I think a couple of us have stuff to kind of go over. And I've thought about this. I mean, this is our third hearing on this. We've obviously had some time to think this over, and I've seen the sign several times coming into town. And I agree with Mr. Appicello that we've talked a lot about whether or not the trees were allowed to be cut down or requested to be cut down, and at the end of the day, and I think we kept the record open for a couple extra weeks because of that. I don't know that that's really relevant at this point. But again, that's my one person's opinion. I think when it comes between a legal conformity, you look at the fact that the sign was expanded sometime 1990s, or we don't know I don't know if we know exactly the date, and we can't find a permit. I don't know if necessarily we're saying there is no permit or we just can't locate a permit. To me, the issue of that actually there could be a lot of arguments both sides with that. There's not a permit, but then again, are we stopped at this point from asserting that it's a non-legal conformity after 20 some odd years of it existing in its current condition, and but anyway, without even having to go there, I look at it and I look at the code, and the code says, as Mr. Appicello and actually as Richard Townsend has said before, that it's clearly a non-conforming sign. The way the code is written, it appears that if the sign is damaged and it can only be repaired if it costs more than 50% to repair a sign, then the cost of a new sign, a conforming sign, then the sign can't be repaired. The position of the city is, since the sign can't be brought into conformity because it's an undeveloped lot, then the cost to bringing it in, the cost of a new sign is zero, and obviously 50% of anything is more than zero, and therefore the sign can't be repaired. I agree with that in one respect, and in another respect, I don't know that I do. Where I'm coming from there is we're assuming that you cannot make the sign conform, you cannot put a conforming sign on that property. I don't know that we can consider is that the one way to put a conforming sign on that property is to develop the property. Now, what's the cost to develop the property? Do they own the property? If they do own the property, then all they have to do is develop the property, and then they could put a conforming sign on the property. The cost of developing the property is obviously going to be a lot more than zero, and 50%, in my opinion, probably 50% would not exceed 50% of repairing the sign. So, in other words, I think you could put a conforming sign on the property where we may be assuming that you cannot. If that's the case, then I don't know that this sign could not be repaired. On the other hand, I look at the code, it says, let's assume the other way, that you can't repair it. While if we take that assumption, I don't see anything in the code, and Mr. Apicello may be able to point to something if I'm wrong, that prohibits them from utilizing what is there. So instead of the sign being repaired, what's to say they say, well, okay, we won't repair it, we'll use it in the condition it's in. If we have a half a sign that's been destroyed by a tree, we'll use the other half. Maybe we can, maybe they can still do that. That was the case in Florida for a long time with billboards, where you're not allowed to repair them to a certain extent. I think Mr. Apicello may have worked there too, and he probably saw some of that. And so you would see on the interstate billboards that looked like they were just dilapidated and falling down, and yet they had advertisement on it, and you wondered why. Somebody didn't fix that sign. As a kid, I always did, and then when I got older, I realized it. This is a little different because, as Deborah's putting up on the screen here, the sign has already actually been repaired. So now we're at the situation where we're asking for forgiveness rather than permission, I guess. I mean, it's already done. So if we decide tonight that you can't repair the sign, but they could use it in the condition it was in, well, what does that mean at this point? I don't think the sign was completely destroyed. Do we have pictures, Deborah, of the sign prior to?
No, this is the first time the city saw it.
I vaguely remember seeing the sign at one point. And again, maybe some of the other commissioners can chime in on this particular point, but I vaguely remember that sign being where the bottom of the sign was still.
I'm going to caution you not to enter this into the record.
Okay, that's fine. In any event, I think that the sign could still be used. That's before the destruction there. So I think that the way the code's written, they may be able to use the sign in the condition it was. If it's damaged, is that going to impact the city here? I look at there. We have at least, I think the testimony before from Richard was we had at least 5 other non-compliant signs in the city. I'm not going to point out the advertisements on them, but I think a lot of us here know which ones we're talking about. If one of those signs is to get half of it knocked down, what does the city do then? Do we say that you can't repair it, but we don't have anything in place to say you have to remove it, so it just sits there, they paint a half a sign, and now we have a real eyesore in the city? And I feel that may be the situation. So I'm thinking, I thought about this a little bit, and I don't know how it would work out, but what I'd like to see is something where everybody would win here, and you don't have a winner and a loser. Unfortunately, I see that the applicant's attorney's not here, so I don't know that they are able to speak to this, but at this point, we have a sign that I feel there's an issue with the code, and other commissioners may or may not agree with that. We've clearly put something in place now where other people cannot put non-compliant signs up. So the goal was to get these signs off the road, so to speak. We've clearly accomplished that, I feel. I'm not sure that we drafted the ordinance the way we wanted it to get these removed. I think there may be other ways to do that. Sunsetting clauses, et cetera. But again, for tonight's purposes, I don't know that this sign would have to be removed under the current ordinance, and I think that might set up something for an appeal by the applicant. What I'd like to see is, like I said, a win-win situation. Thinking out loud here, something to the effect of, Richard said before that I believe the city doesn't get any revenue from the or any taxes from this sign. Is that correct?
I don't know that.
I believe he testified to that before, and maybe if you don't know, you don't. But under that assumption, if the city doesn't get anything from that, something to this effect of if you entered into some type of a stipulation or an agreement, and Mr. Apicello would have to speak to that with Mr. Wyman if he is still.
I'm going to interrupt. I apologize, but this is a quasi-judicial proceeding, and so your constraint is you must apply the law that exists to the facts adduced at the hearing and in testimony and in writing. This is not a legislative action or a negotiated development agreement where we would enter into negotiations with a developer, and even with, for example, under the development agreement statute, and this is law, you're not authorized to vary from the mandatory terms of your code when entering into a development agreement. So only where your code gives you authorization to negotiate such matters are you allowed to vary those matters. So
Are you
again,
familiar by the, I'm not trying to interrupt you, but are you familiar with the code, whether or not it allows for that, just out of curiosity?
not in the context of nonconformities.
Okay, so it does not allow for it, or you're not familiar with it?
Not in this context.
Okay.
I mean, there are other provisions in the code where, that not in the nonconformities article.
Okay. And again, if it's not in this context of this code, then it is what it is. I'm concerned that I think the way it's written now, we may have a situation where we've got a half a sign sitting on a piece of property that the code does not allow us to remove or request to be removed. In any event, that's kind of where I was at with it. So I'll hold the rest of the comments of what I'd like to see go on, but
Thank you.
that's it.
I caught myself playing lawyer the last time and reading the codes and saying this and saying that, and then I got to think about it, to reflect on this whole thing. I think one of the reasons I got involved on Planning Commission is because I was upset with involvement in my life by the city on certain levels, and this is touching a lot of hot buttons for me, the tree removal, the signage, and things like that, and I'm just... We have a sign that was built legally, people using it in a legal manner. They were annexed in, rules changed, whether they had an influence on it or not, I don't know. But they have a sign, it produces income, it serves a purpose. To me, I don't see anything harmful about it. I haven't heard any testimony that says it was a potentially dangerous sign, engineering-wise and such. Any wind could blow it down and kill somebody. We have issues with trees that would have been allowed to be cut down prior to our ordinance being enacted, and then all of a sudden the city has taken these trees and said, well, we own them and we're going to tell you when you can and can't remove them. And so we're kind of at the mercy of the city with this thing. I'm tending just to say, leave it alone. That's kind of where I'm landing on this. I'm not really thrilled with the way this has been handled on the appellant side, because we've all had to apply rules and follow rules, and I think some have been kind of ignored. But I also say this is a business. This is an income stream for them. It's important to people in the community, obviously, because they advertise on it. They pay money to be there. And we're going to just come along and say, well, because we said this, you don't get to have it anymore. And I'm offended by that. I really am. If it were me, I would be quite upset by this. And I'm going to probably end up just saying I'm going to vote for the appeal.
Mr. Bryson.
The city's made a good case. The way I see it is the repairs that were made were what the value of this song. And I think, the damage can happen. Figured out that was to go today, the rules that we have wouldn't be allowed because there's no development on the property. Go back and I look at the original time with the city on it. I think the sign strikes out on 3 different levels. I wish it did, and I wish the appellants had it. proper sign and develop the property, would like to see it developed, but that's this one.
Well, from my perspective, I think there have been at least a couple of occasions where permits were ignored and work went ahead. The original expansion and then the subsequent repair after this most recent incident. I think the city, was pretty clear that the goal of this statute was to get the non-conforming signs eventually shut down and removed. I would agree with Mr. Kidd. I don't think they've figured out a good way to get there yet. I don't think there's any vehicle for that to really occur in our lifetimes, because many of the signs that are non-conforming are more substantial and are probably not likely to blow down unless we really get some very, very unusual winds. So I think the city was within its rights, subsequent to the original installation, to change the rules. I think there is a mechanism for the appellants to have a conforming sign there, which is, as you suggest, to develop the property and go forward with that. My own belief is that it is an illegal non-conforming use because it exceeds every threshold, either the approved threshold or the approved sign size, which would be 50 square feet. I don't believe, according to our statute, it qualifies for repair. Repair to me is something less than a complete rebuild. And I think the important thing, as Mr. Apicello has pointed out, we're not here to legislate. We're here to look at the case relative to the code as it's written. I think that the appellants have another avenue to have full use of their property as they see fit, but that's through the legislative process to change that so that it recognizes their particular situation and similarly situated individuals at the same time. So my position would be that we would go ahead and move to deny the appeal based upon what our criteria for approval and denial is, not what our motion is. And perhaps at that point in time, and as the minutes are reviewed by City Council and by City Attorney, some other avenue exists to change the statutes in the future. But right now, we have what we have. Does anybody have a motion they want to introduce on this matter?
Mr. Chair, I'll move that we deny the Bruner family bill for the file 8012.
Do I hear a second? So moved. I'll second that.
Sorry, did someone second that? Second, yeah.
Would you call the roll, please?
Kidd,
No.
Williams,
No.
Bryson,
Yes.
Evans.
Yes.
That's
According to the motion has failed. And the practical import of that, Mr. Apicello, is?
Well, if the motion failed, then the original decision was going to stand.
So the original decision of the planning director stands.
This is a de novo hearing, and so it's an opportunity to have you decide anew the decision. If you can't reach a decision, then I guess that they don't get to appeal your decision to the city council, and they're kind of in limbo. So frankly, the prior decision's the only decision that is a final decision, so.
Well, I'm now lost even further.
Well, this is difficult because at some point, 2-2 has to change to something if you want to actually have this go forward. I mean, they have a right to appeal this decision to the city council, but
If what happens?
if you have a 3-1 vote.
Okay.
So hypothetically, if we were to have a 3-1 vote to deny their appeal, they have the right to take that appeal to city council.
Yes.
But with a 2-2 vote, they don't have a right.
I think, as I stated earlier, I think with a 2-2 vote, what you've done is essentially caused this board not to perform its duty of making a decision in a quasi-judicial action. And this matter will have to be continued to the next meeting when you will have additional members. Those members would then have to review the entire record, and then maybe you'll have a different vote.
What would be our process to move to that point if it was the,
I mean, if you're not, if nobody's going to move here, then I just recommend that someone make a motion to continue this matter to the next meeting, or to a special meeting, and that whichever board members can make that meeting will have to review the entire record and break the tie. Otherwise, you're just stalemating.
I mean, okay, so the first I thought you said, and now I think I understand, I thought it was when it was 2-2, it was an automatic denial. It goes back to Mr. Townsend's decision, and therefore they'd have a right to appeal. That's not the case. You're saying they'd have to come.
I don't think so. I mean, if the code said that, that would probably be an acceptable alternative, but the only final decision we have is his decision. An appeal was initiated, and I think that appeal has to be finalized. So I apologize if I confuse things, but I think you need to continue.
If that's the situation, then I would make another motion just to give, if nothing else, to give the applicant clarity of where to go with this, and not to come back, have another 2-week delay, which I won't be at. So now we'll be 4-4 again. And then if it goes, heaven forbid, that's a 2-2, or if it's a 3-1, then they have an appealable right at that point. They have the right to appeal this to City Council now. If a different motion is made, and so to give clarity to the applicant, to give them direction and to expedite the process, I will make a new motion if that we.
Please do.
Okay, I would make a new motion to deny the appeal.
do I hear a second?
Not sure, can we re-bring it up since we've already had a vote on it?
Yes.
Yes, we can.
Yes. Remember, this is a person who voted against the last motion, so that is within Robert's rules, someone who can make a motion even for reconsideration. You could actually make a motion for reconsideration of the last vote because you voted against it, so you wouldn't actually have to make your own motion, but either way, it's acceptable.
Okay, I'll second the motion.
All right, all those, Kate, will you call the roll, please?
Sure. Williams,
No.
Kidd,
Yes.
Bryson,
Yes.
Evans.
Yes.
Okay, motion carries.
I'm going to, we need to reduce this to writing. I've actually gone a little further than staff had, and I'm wondering if we might want to go back to staff's earlier version of the findings, because I just don't think we'll be able to resolve this matter tonight if we have to.
What were staff's,
I'm going to,
Well, we've drafted a final order and left blank so that we could fill it in once you came to a decision. So we have a couple different versions of that. The city attorney
what I can
suggests...
do is I can take the earlier version that was maybe more simplistic in terms of get into all the bring that to you. I can also bring you a more fleshed out version. Again, what we want to do is achieve a final decision, which is not the tentative oral decision. It has to be a written decision, which they can appeal. So I'm going to go and do some quick drafting, and I'll come back with two options, a simplified version and a more detailed version. You guys can decide that. But in the interim, you can proceed with your discussion about the so I'm going to ask to come back and approve findings at the end after you do this report.
All right, please do. All right. Just again for the record and as a matter of clarity, that what is the status of this hearing?
So the hearing is closed, the record is closed, the tentative oral decision is made, and you're directing the city attorney to return with written findings for your approval at the end of the meeting tonight.
Thank you very much. Next item on the agenda, clear vision area requirements. File, thank you.
Thank you, folks.
File ZOA 2012-05, continued from December 18th, 2012, January 15th, 2013, and February 5th, 2013. So amend Section 17.52.060 and 17.52070 to clarify clear vision requirements, decrease the overall clear vision area, and exempt pre-existing features.
All right, here we are back again, talking about clear vision. I have made some changes based on what we talked about last time, and I will review those. And I have also asked our city attorney to take a look at the code and the code amendment, and I think that he would like to spend a little more time with it. I don't anticipate a decision this evening, although I think, depending on your preference, we could send it on to the city council. We could get it in a form where they could consider it. I will say, before we get into the details, that we do have anticipate that we'll be sending out another Measure 56 notice with other items on it that we want to change, probably in the summertime. And we could hold this at this point. We've changed it somewhat since we submitted our DLCD notice and sent out to the neighbors last June. And we also have discovered that there are a couple other areas of the code where we'll have to do a follow-up amendment if we don't, stop right now and add those in. So I think that's something to keep in the back of your minds, that we could either go ahead and get this part hashed out at this, here and then at the city council, or we could maybe just delay our decision on this until we renotice with a refreshed and revised version of what we initially proposed, and anything else in the code that needs to be updated as well. Having said that, I think that our discussion has been very useful in trying to figure out what's important to the Commission about clear vision, and I still have some things that I would like to clarify this evening. So if I may, I'll just go get into the detail here.
I wonder if I couldn't add a third potential option, which is to continue some discussion tonight around the current ordinance, not with a view to passing the ordinance tonight, but with a view toward adding that information to a future, more comprehensive revision.
Yes, that would be ideal. So, we have never really had a problem with measuring from the property line. From what I can tell, nobody seems to be arguing that anything else would be more reasonable. because we want to preserve our right-of-way for future improvements to the street and for that area that is between the fog line and the property line where pedestrians can walk, whether it's improved or not. Now, we did talk a lot over the last couple times about the size of the triangle. Last time, I had been proposing 10 feet for the side adjoining the controlled street, and then it would extend to the end of the property, the other opposite end of the property. I believe it was Eric last time said he would rather see a specific number and not leave that a variable depending on the width of the lot. And so I did take out that language referring to the furthest point on the lot and put in 50 feet. And it seems that that approximates, it's not going to make a whole lot of difference in the triangle, but it does give that 50 foot of view down the uncontrolled street. And then in the exemptions, I did add some language, so we'll go to that. Okay, as you recall, we defined point A as the intersection of the property lines there, or the extensions of the property lines on a curve. And so when we have a controlled street and an uncontrolled street, we were talking about 10-foot length of a side on the controlled street, and then 50-foot, and in some cases this may extend beyond the lot line. In this diagram that I have here, it actually did extend into the neighbor's lot, but in a very minor way. On an uncontrolled street, we have an uncontrolled street here and also in this direction, and in that case, we would have two triangles that overlapped with a 10-foot and then a 50-foot. So you'd get that 50-foot long view in either direction. And then we got into driveways and alleys. And the commission seemed to support restrictions in a driveway for commercial use or a service driveway or an alley. It was not so sure about a driveway in a residential area, although we did have some support for that. So I did leave it in, and I do want to point out to you that we do have exceptions. A lot of, we have a pretty good list of exceptions for what can go in the clear vision, and some of those things would be existing buildings and existing parking, required parking spaces, existing driveways. So mostly what we're talking about is applying this to new development or redevelopment, new fences and that kind of thing. We did talk about the difficulty in controlling this when we don't have permits for fences, and that may be something that we want to consider for next time. And let's see here. I will go on past the clear vision, the driveways in the clear vision. We do talk about that a little later. Other code sections, one of them was this in the actual parking standards about commercial driveways. And so we'll want to change that if we decide to wait and, well, either way, we'll have to change that to update that as well. So what I did add, this is in exceptions, and it says existing driveways and existing required parking spaces may be in the clear vision area. New required parking spaces shall be outside the clear vision triangle. New garages to be accessed by driveways that cross over clear vision areas must be set back at least 20 feet from the clear vision area. So what we're trying to get at here is if they already exist, there's nothing we can do about it, retroactively. If we are approving a new house that has a garage that is serviced by a driveway that would have to cross the clear vision area, the 20 feet required in front of the garage would start after you get through the clear vision area. So they could park a car and not have it be in front of the garage, not have it be in in the clear vision area. Does that make sense? Do you get where I'm going? Do you like where I'm going? Okay.
I understand it, but
Okay.
I'll wait until you're finished.
Okay, all right. So that's one thing we can still discuss. Another thing I did to the exceptions part, and this is right at the beginning of exceptions, there was some support for the language in the other part of the code that said that the city engineer could vary the clear vision requirements, making the triangle smaller or larger depending on topography or speed of traffic or other perceived hazards. So I did add that in here. And this is, so it says the minimum clear vision area may be modified by the city engineer upon finding that more or less sight distance is necessary. I did ask Richard Apicello, our city attorney, about that because there was also some concern about having some ambiguity or having some discretion on the part of the city engineer and the city planning director. And, there is a balance there. So that is something that maybe he will look into a little bit more if we give him some more time. Okay, and that's all I added new. The other question that I asked our city attorney was about your concern that by changing this, or even by having maybe a clear vision ordinance, that we would be creating some liability for the city. And he said that, basically, well, that is a concern, but that's always a concern with any ordinance, and that it should not be the overriding consideration of the Planning Commission. The Planning Commission should determine, what they think is appropriate, and then if you get too crazy, I imagine he would say, no, hold on a minute. But he was not of the opinion that we had to be concerned and that we could not do a revision to the clear vision ordinance, or we couldn't have a clear vision ordinance because of liability to the city. So, yes, tell me what you think.
Mr. Bryson.
I think you made some here, and I was just watch everything else. Sassy.
Well, or even, if someone decided to put up a new structure or a new fence or something like that in the new clear vision triangle, that would be a problem for them. I mean, they would have to comply. But given the exceptions, the list of exceptions that we have in this amended ordinance, it does give them a lot of latitude in terms of what already exists or what we feel can't be changed. And it also allows, for instance, a fence that is very open, like a chain link or a wire, where we didn't have any exceptions before. And so it does loosen it up in a number of ways.
Trying to look, retaining walls,
Mm-hmm.
properties, that would have to be. They couldn't overlap.
If it's, as far as retaining walls, something like a retaining wall, if it already exists, the exception allows it, and with the caveat that if the planning director and the city engineer find it to present an unacceptable hazard, that, may have to change. But I don't think with anything that already exists that's probably going to happen. And that caveat really was more about for new development, if somebody needs to put some kind of a retaining wall or other structure like that, or if there's topography in the clear vision triangle that doesn't meet the standard, that they have some discretion there, whether to allow it or not. depending on the hazard.
Mr. Williams?
Yeah, the topography one concerns me because I know there's a lot of elevated homes in this area where as you're coming out of your driveway, if you're halfway down, you've got all kinds of vision, but when you've reached the bottom to the street level, you're now blocked. But you could see it within seconds and I just want to make sure that no one's going to get harmed from that, and we can just say, look, we know it's still a safe, clear vision, even though 10 feet changed it. You were in your driveway, you could see it. You hit the bottom of your driveway, you can't see it. You follow?
Well, our measurement for obstacles, our limitation on obstacles is between 2.5 and 8 feet, and that is measured, I believe, let me check here, but I believe that's measured from the grade of the street.
Right.
So there may be some issues there. But, that's why I guess I like the exceptions allowing some discretion on the part of the city.
I just want to stress that this becomes a very flexible issue. And then, I don't know why, and it may have no point whatsoever, but bike lanes is coming into my mind. Will that affect this at all? Everything will still be the same, because it's measured from the point where the driveway meets the city's right-of-way.
That's the distinction. That's why we're going with our right-of-way line rather than with the edge of roadway.
Okay, great.
Because we may add a bike lane or a sidewalk
Good.
at some point.
Okay.
Mr. Kidd?
I don't have a whole lot to add or ask. I guess the only thing maybe we can talk about it maybe another time, but the exception seems to give the city engineer sole authority, one person the discretion to do away with whatever. I think they're probably the best person to make that decision. I agree with that, and I think they would know more than anybody that what needs to be changed, more or less distance depending on traffic speed, roadway alignment. But is there any kind of a path to if someone's property is affected by that and they're being told you can't do certain things now because the traffic engineer is saying that your particular lot needs to have more sight distance as opposed to your neighbor? Is there some type of a mechanism where they can appeal that? If we give I'm just worried about you give that one today it may work great. 10 years from now, you never know who's going to be there, right? So,
well, I think just like the decision, Richard's decision about the sign was appealed. I think any staff decision basically could be
as long as they
appealed.
Okay. I just didn't want them to have to come back if there's something in the code that gives them that right to. Nope. Dictator made his decision, and that's
right,
what it is.
Yeah, right. Yeah, it's always good to have that appeal option.
And but I do think that the city engineer is probably the best person to make that call.
Now, the one thing I would say, I was talking about, we could wait. In some ways, this has been on the books a long time now, and it's not urgent necessarily that we make amendments to it at this time. We could wait a few months, but we do occasionally have a situation where somebody comes in. We had one a week or two ago. Kate was talking to some people who have a very narrow lot, and they're trying to fit a particular house on it, and the 30-foot triangle was really causing them an issue in terms of how to develop. And so to the extent that we're reducing the triangle and making it more effective, at the same time, it may be something you want to go ahead with and do this, and we can fine-tune the other parts of the code later. So, it's up to you how comfortable you're feeling at this point with the language that we're proposing.
Well, if I could, I have as usual, a number of issues.
Okay.
You mentioned earlier that we really need to think about what's appropriate for planning. And I continue to have a concern that we're addressing a non-issue with a lot of effort. The statistics that have been presented don't seem to hold up a lot of reason for a comprehensive review of clear vision. I understand the logic in reducing the leg of the clear vision to make it more palatable and to potentially use up less property for clear vision. But I think there's a couple of things that we need to think about. Correct me if I'm wrong, but the largest municipality in the state does not have a clear vision requirement.
I will say that I cannot find one in their code.
I looked very, very hard for 2 days to try to find it.
I would not swear that it's not there, but I can't.
I think
I
that
can't find
they
it.
talk about not clear vision, but they talk about sight distance.
Mm-hmm.
They talk about it, and I'm referring to the city of Portland, and they talk about it in very general terms.
Mm-hmm.
I'd be a lot more comfortable with a small municipality taking a very aggressive stance if there was some other precedence in the state for that kind of a stance. I'm not saying that it doesn't exist, but I haven't been able to find it myself either.
Mm-hmm.
The other big concern that I have, let me hit a couple of the minor concerns. I think that 17.52.060 in and of itself is a very adequate statement of clear vision requirement, which is keep your stuff out of the corners so that you're not obstructing a view.
Mm-hmm.
Really, everything that flows from that is how far back do you have to keep that clear. But at some point in time, people have to be responsible for their own actions, to look when they come to an intersection, to slow down, to stop, and not rely upon the appearance of a clear right-of-way to cross the street or to go forward or to make their turn. So if I were asked tonight, I would say, well, let's continue 17.52.060, and then let's do 15.52.0704, which are the exceptions. Basically says that we're going to use common sense as to what dictates a clear vision requirement. We're writing so many exceptions in that it almost, and so many grandfathered clauses in that it almost doesn't make any sense. It's not as though we're having a huge amount of development at every intersection, where we've got 50 or 100 or 200 permits backed up, that we couldn't rely upon common sense of the engineer, planning director to look at something and make a decision. One other...
So, wait a second. So you're suggesting that we don't define a triangle, and we just say...
define the heights, the 2.5 and the 8 foot, so that things are out of that, and use the planning director or the city engineer's discretion as to what constitutes a hazardous encroachment on a corner, rather than laying down a series of rules about driveways and in effect, increasing setbacks and everything else. I don't think we know what the impact of this really will be. I think we've got a good intention, but I think when you begin to say, well, on a corner lot, we're going to push the garage back an extra 10 feet, that may make that lot unbuildable, because you've pushed back 10 and 20, and a garage is nominally 20, and then you've got the rear yard setback, right?
Yes.
So you...
Well, except that I would say that the 10 is only there at the corner, and then it diminishes, over the 50 feet.
Front,
Yeah.
On that corner, if my garage were to be at that corner...
Well, it can't. It has to be at least 7.5 feet back,
Yeah.
5 foot back for a. It has to be 20 foot back where the driveway is.
Plus 20, plus the depth of the garage, plus the rear yard setback. That's how deep the lot is, right?
Okay. Well,
At any rate,
Okay,
what I'm saying is,
yes.
we start getting into a lot of mathematics that we're not really sure what that impact is going to be. And so I'll leave that alone for the moment. One other minor issue before I get to the major one is, in 17.52.0701, it talks about clear vision areas at intersections with Highway 101 must meet Oregon DOT approval. That, to me, seems to say that on any intersection on 101, ODOT rules, this doesn't. Okay? Which brings me to my big point, which is, along 101, we have basically controlled intersections all the way up and down, and we've got a commercial area. And we have many of our buildings that are right up to the sidewalks. If a building were to have a fire and be destroyed more than 50%, according to this statute, they need to then conform with the new setback requirements. If it's a small building and you push the size of their rebuild to a smaller building, you may run into problems with the insurance companies as to what they're going to pay on that rebuilding. Because there are rules about the amount of insurance, how much they'll pay, how much you have to rebuild in order to get those insurance payments. So all of this points me to, we don't have a problem. We're creating a rule that we don't really know what the net impact is going to be, either new development, redevelopment, or anything else. So, again, we're just in a discussion mode tonight, and I just wanted to throw all of that out. It's like the old saw about clapping your hands to keep the elephants away. Everybody will say it works, but we don't normally have elephants in Lincoln City. Are we doing something that needs to be done without fully understanding the impact of it?
Well, I think we've kind of hit on that before, that it does exist now.
We do have a
30 feet.
triangle now.
Right.
I understand. Just to be argumentative for a moment, I do understand that we have a rule.
Right.
I still don't understand that we've got a problem, because
I completely agree. But if we're going to have a rule, I'd like to change it to something a whole lot smaller than what we have.
don't disagree, if we're going to have a rule, but
Right, so, but the option is, we either do nothing, do we have the option to say, let's just dump that whole thing?
Well, do we have the option to write a rule or to ultimately pass a rule that we like, that makes sense? Or does it have to be more complex?
And I'm not being argumentative, I'm asking a question. Can we change it? Can we just say, we're not going to have this? It just doesn't exist in Lincoln City anymore.
Yes.
Do we just eliminate the 30-footer and just say we won't even discuss clear vision?
Wouldn't that be legislative, though? I mean, can we do what we...
That's something we should
Well, we'd have to recommend to the council.
Right, I was going to say, I don't know if
We can recommend to the council.
Right.
You could recommend that we get rid of it.
What?
So the question is, would we be better off then or not? Or do we want something somewhere in the middle?
Well, so I think before we had stated at some point that there haven't been any reported accidents or anything like or associated with site distance in driveways, or at least we haven't documented them anyway, I should say. Is that right?
We actually, and I took that slide out because I didn't think we needed it anymore, but the information I got from the police was that, and I tallied up, I think we had like 240 accidents that occurred, and what they reported that I saw was where it was. And if it was at two streets, I assumed it was in an intersection. If it was at one street and an address, then I figured it was probably a driveway. And what I found was, in just tallying them up, the ones on the highway were about equal between what occurred at intersections and what occurred at driveways. On the local streets, there were fewer at intersections than there were elsewhere on those local streets. And because a driveway just isn't to like a single-family home, it could be a driveway to Tanger Outlet or to Safeway, or, I mean, some places that generate a lot of traffic. So those driveways, are maybe more significant in terms of needing to control them. But the example that I showed you right now, we have this reference in the parking and loading section of the ordinance, 1752, that says, and I showed you, actually, I think I still have that in my slideshow, if I go down a little bit further. Yeah. What it requires, that section for commercial drives, is something that doesn't even get, I mean, it's only the red part here. And so it talks about from the center line, 20 feet from the center line, which basically covers the driveway itself and no clearance beyond that. So what we have right now isn't particularly useful in that regard. And you can see Safeway here has provided way more clear visibility than even we would require with our new ordinance. So.
But you do realize that at this particular example, Safeway is not the problem. It's the other driveway on the other side that is the problem, where that white car,
here?
That is the problem.
Well, and you see this building is pretty close to the, to the right-of-way, isn't it?
It's also the
slope.
The slope of the driveway coming into it, because people will routinely, as that white car is doing, pull out into the traffic in order to be able to see.
Mm-hmm. Well, I can think of a couple places in town, and I mean, this may be one of them. On 14th Street, where we have the big green building, and there is a stoplight there. But it's for me, and I drive there every day on my way to work. I can't really see. I have to assume that when I get the green light, I can go. Because the sidewalk is right there, and I can't really see if anybody's coming out of control on a skateboard down the sidewalk.
And I can tell you, I live on that street, on the west side of that street.
Mm-hmm.
Coming from the other side of that street, you clearly cannot see when the light is green if there's a car coming. A lot of times, because cars park and they're parking on the road there, but they park right up to almost to 14th Street, you can't see around them.
Mm-hmm.
That, and I actually have a kid now who is old enough to drive, and I tell them, do not ever jump that light, because the light, that another whole issue, but that light changes simultaneous. When one's red, the other automatically is green. There's no delay.
Mm-hmm.
So if someone's running that light and you jump the green and somebody comes through there, you can't see them, and you're going to get hit. So, yeah, there's definitely some other issues.
Deborah, there's all sorts of bad intersections in this town. About it, and we're all aware.
Mm-hmm.
I have
Mm-hmm.
How long is it? That clarification.
Seems like in my original report, I mentioned that I think it was original with the ordinance, which was, the most current ordinance, I think, was 84. I mean, the biggest, the big overhaul of the code.
That interpolation of the ordinance has been in place since 1984.
Mm-hmm.
And any construction that has taken place 84 would have to be in compliance with that.
That's right.
Are there examples that you know of that are out there now that are construction projects that are existing that compliance isn't being met now?
Are there people pointing to other people's property and saying, that's a problem, that was built illegally, or that they've added something since then that is non-conforming. Kate, do you get complaints like that?
No, not really. That doesn't mean they don't exist. And it's possible that since 1984, and this may have even existed prior to that, that's just what our current code says, that it's at least as old as 84. But it's possible that that previous staff possibly didn't apply it to driveways, but to buildings, certainly. It should have been consistently applied.
And that's an interpretation, for instance, because the driveway's flat. It's not between 2.5 feet and 8 feet above grade. But if you park a car on the driveway, which you're inclined to do, then you've got an obstacle. So that, that could be a staff interpretation.
When Mr. Kidd brought up something, just to interrupt here, he mentioned the word parking. And when you think about clear vision, I think we haven't even discussed the impact of on-street parking to clear vision, and whether or not any on-street parking within that 50 or even probably 70-foot leg would nullify the clear vision. So we've got a potential problem where you could write a clear vision statute at 10 feet and 50, for example. And then you've got somebody, let's say they've got 2 cars parked on that street, a reasonable distance from the corner, but let's say 10 feet, 15 feet from the corner itself. They've automatically blocked your clear vision. The house hasn't, but the on-street parking has.
And that's something that our Public Works Department needs to be, wary of, and when they're placing parking spaces.
I think it's more than being wary of. I think it nullifies.
Well, depending on where they strike parking or no parking areas, that could address that problem, is what I'm saying.
But when you put the on-street parking, you deal with the driveway parking, you deal with the clear vision all at one time. You put all of those things together, and I go back to my original point, we don't really understand then what's going to happen. What I'm saying is, you could pass we could pass tonight the 10 and the 50-foot legs, and put it into effect, and tomorrow morning 2 cars could park on that 50-foot run and completely block vision onto the street.
Let me think about that. Actually,
unless what you're saying,
I'm not
there could be
sure
no
that's
parking
true.
within 50 feet of any intersection. And I don't know, does the code say that?
I don't know, and I'd have to check to see what the
Because that's the
Public
core-
Works'
that's the-
policy is as far as
follow-on
that
to it.
setback.
Because if you've got one code that says you've got to have 50 feet clear, and actually that line would extend further than that if there were a car parked there.
We can go back to one of my diagrams and take a look in a minute, but I also looked up on the city code what it says about rebuilding nonconforming uses that are more than 50% damaged. And it says a decision to approve an application. Actually, if it was a commercial use, it would come to the Planning Commission. And it says a decision to approve an application to restore a nonconforming structure must include findings of all of the following: that the damage was not intentionally caused, that the doesn't increase the nonconformity, that the restoration is according to the fire marshal, building inspector, and floodplain, if necessary in conformance with the geotech report, does not encroach unlawfully on adjacent properties, restoration complies with reasonable conditions, to mitigate any new or adverse impact on adjoining property. And in the case of the commercial structure, the reconstructed use or structure would not interfere with the intent and purpose of the zone in which it's located. So basically, this is saying if a commercial building, it doesn't say anything about clear vision. So it says it can be restored to its former height and footprint. So I don't think that is as much of an issue as maybe you thought it would be. So that's something that we can, look at further.
Well,
But
then, if, wherever we wind up going with this, I think that needs to be clarified. If we do wind up with a clear vision issue, that, let's say it applies to commercial buildings in the GC zone or wherever, then during a rebuild, it can't apply. I mean, it should probably
Well, it
be
doesn't call
explicit.
out clear vision, it does call out building inspector and floodplain manager approval, you know.
Well, again,
But
then
it does not call out.
that's
clear vision.
discretionary, and if that's discretionary, why isn't everything discretionary?
So, well, okay, so, all right, and then let's go back to one of Graham's here.
All right, so
And
let's take that now. If, let's say that this is not Safeway, but let's just say it's a big old driveway there.
It's a big what?
It's a big old driveway.
Like a residential driveway?
Whatever.
Well, let's pick one, and
Let's pick
we've
it.
got lots of
Let's
pictures
pick
here.
earrings.
Let's fix it.
Okay, so we're saying that 10 foot back from that point A,
Deborah, I'm sorry, is there a way to enlarge that just a bit?
She's probably got it on a PowerPoint.
C,
Beautiful, thank you.
now, so we're saying 10 feet back and then 50 foot
Over.
over.
Right.
Okay, so you're sitting here 10 foot back in the driver's seat.
Yeah.
And say, for instance, then a car
Yeah,
parks here.
right here. Let's say you.
Car would have to park about right here to really interfere with your,
Well, let's
with your
say
view.
you parked the nose of your car at 50 feet. The top of your car is at 30. And then your buddy parks behind you. Their nose is at 30 and the back of the car is at 10.
so you're effectively blocking this view.
Block all the clear vision. So we have then a well-intentioned ordinance that is not supported by the parking requirements
Yeah,
of the street.
That's
And
right.
so
We have to make sure that those two work.
we definitely do,
Together.
because what we're then asking is that the owner of that property bears the brunt of the impact of the legislative change, whereas the drivers on the street can mitigate it, or not mitigate, they just completely do away with it by parking there. So if you take that, let's take it another step further. We now say that we're going to reduce the amount of parking on the street in order to have it consistent with clear vision. That what we want to do.
Yeah, yes, right. Is that another negative?
Then pretty
Richard.
soon, well, you can't park in your driveway.
We have, in your absence, we have ranged from, let's just throw out the clear vision ordinance.
I have raged. I won't blame anyone else.
All the way to, let's take a break and bring it back in the summer, or to, let's persevere and send something to the council, and at least we've got, we've hopefully made some progress. So, these are things that we,
Look at this as brainstorming. So
yes,
it never hurts anything. So what we're going through is
I think it is too. I think it's very good. It's just, and now I'm asking, where do you want to go from here, I guess. So shall we explore some of these things further? Would you like to send something to the council in the next, meeting or so?
Can I ask a question? I didn't bring my computer with me, so I can't look this up, but some jurisdictions have under legislative procedures that, and correct me if I'm wrong, this is a public hearing, right? So before I don't think there's anybody here, but we should at least ask if anybody from the public wants to testify. But generally, you sometimes have in your code that if the Planning Commission fails to make a recommendation on a legislative matter, it will automatically go to the City Council. Do you have anything like that in your code?
Oh, I don't. I'm not aware that we do, but I better check.
Well, I would be reluctant to have this go to the city council, speaking for myself, in the current format. I think there are, in my mind, too many questions that are unanswered as to the impact of the proposed legislation, and not enough demonstrable need that we need to rush into it. I would be much more comfortable, again, speaking only for myself, deferring this to a more global review of some of the issues that perhaps I have raised and others have raised, so that later on this summer we have a more comprehensive revamp of this and the related codes.
If you don't mind, I'm sorry for the interruption, but I'll go look at the code in my office just to check to see if there is something. You might consider just continuing it, since this is an advertised public hearing, I believe. If you continue this matter until we can look into that, that's another option available to you.
What's the sense of the council? Shall we move to continue?
I'm good with continuing. The one thing that I just wanted to bring to this is, we have an existing ordinance. And while I'm not a big fan of laws and more laws, I know, having been a home builder and a business builder, I was constantly looking for direction from the city. What can I and can I not do? And then without fail, when I was just about done, someone would walk up and go, "Oh, you didn't do this. And now you're going to have to tear out all your drywall, and you have to go back and do this. Oh, now you're going to have to build a new retaining wall and do this." And that's all anyone's looking for, is just, what do you want? I'll do it, and leave me alone. And so I just want to make sure whatever we do, it's simple, it's clear, and it's concise for someone who's building, remodeling, modifying.
Well, I also come in from the same background, but what I worry more about is what we used to call in the healthcare business iatrogenic consequences, meaning when we introduce something that we really don't know what the ultimate impact is going to be, in my mind, is worse than just leaving it alone for the time being. In my own mind, I don't know what the impact of this is.
I think that, I agree with what you're saying. I see where you're going too, actually, Don. I agree that sometimes less government is better, less restrictions is better. But in this case, and that's why I was asking, is there a documented cases of accidents and things like that? And the second part to that question I didn't ask was, do we have a lot of people, you made one reference to one a couple of weeks ago, but do we have a lot of people coming in saying, I can't build because of the way the code is now of clear vision?
We had, I think what brought this up and why this is before you now is we had a contractor who had laid out his site plan, but the driveway was in the clear vision. And, it's flat, it's ground level, but if somebody parks on it, it's an obstruction. And at that time, the contractor kind of took issue, and the city could appreciate the fact that it was controlled. There was a stop sign just, a few, 50 feet away. And the question was, is really a 30-foot triangle necessary, especially in this case where there's a stop sign and they have to stop anyway. And so that was one issue that comes to mind. And then this other more recent one was it's just a matter of, for their lot and their particular house plan and the way they wanted to set it on the lot, it didn't work. And people have been having to make adjustments like that, all the time.
Does our code give us authority to do a case-by-case analysis of that? So this similar, like this lot you're talking about, it's kind of similar to when you're asking for a variance. Is it a situation where, you know what I'm at?
Well, I said to these people, in fact, I looked at the plan and I said, well, you could put the garage on the other side, or you could put the door on the other side. So it seemed to me that there were options that would be workable. So even though they didn't like the 30-foot, I didn't see that it would really prevent them from or be a hardship for them. So I said, you can apply for a variance. I don't see the grounds for a variance.
But there was an avenue there to try to go around what's currently in.
So the thing is, if we feel 30 feet is excessive, then, the sooner we address that, the better. But we certainly don't want to address it with an amendment that causes additional problems.
Right.
So.
Yeah, and I see exactly Mr. Kelly's going with that, and I would agree with him on that. This point, maybe keep this discussion, like you said, we're kind of brainstorming, whatnot here, and maybe come up with some ideas if we're going to make changes over the next few months, but I don't think I would be comfortable to the next level going to city council yet either. Now, Mr. Apicella may tell us that if we don't make a decision tonight, then it goes to them automatically. I don't know.
I know that's true for somebody who's asking for a zoning change.
Right.
There's
But
a
in-
section of your code that section 17.
17.88.040.
Right here on the screen.
And what it really says is that this applies to amendments to the text of this chapter, which is referring to Chapter 17, so it applies to changes to the land development regulations. It says you are to recommend approval or denial, and you can take such time as you need, but then the next paragraph actually says 60 days. If you don't make a recommendation, it's a recommendation of approval. So although that's probably more geared toward the map changes, it does appear in this section, and this section does concern comprehensive plan, map, and text, as well as changes to the text and zoning map. So Chapter 17 changes. So I believe you have 60 days. This was initiated by the city council, so of course they could give you more time.
In this case, so there wasn't an application, actually, and it's 60 days
Well,
after.
initiation,
So-
if you go up in the paragraph here, it actually says there's a number of ways in which these kind of amendments can be initiated. One of them is initiated by the city council or planning commission. So I would suggest that if you're not comfortable with where this is, you could recommend denial to the council and ask, and something we had talked about, is that because of the way this has evolved, the original notice to the state under 197-610, I believe, kind of, this has evolved so much that it's not really recognizable as to what was originally sent to the state as we were initiating a land development regulation. So we had actually talked about maybe re-noticing this. So if that might be part of your recommendation as well.
If you wanted to recommend
Against it.
against it, then, I can, in my staff report forwarding your recommendation, explain that we're not ready to make a recommendation, and so that's why you're recommending.
Just so
this
I
approval.
understand, because being new to this process, and I just had assumed we were just storming, that you were just bringing us an idea that says, hey, here's what we're thinking about doing.
We
I
bring.
didn't realize the clock was ticking every time we talked to you.
Well, yes, and I wasn't really, cognizant of that either. But we did open the public hearing, so we started the procedure
When did
in a
we open?
timely manner last summer. And then we tabled it because the engineering staff wanted to have more time to look at it.
Tabling then stops the clock?
Well, that's.
Well, there
that's
isn't a
good-
clock on legislative.
And I don't think we
matter, so-
have to really,
I just want to know for
Go there,
future
but-
discussions.
well, we can report back to you on that. We can do a little work.
I mean,
and-
each time you come,
No. It was proposed by staff as an amendment. And we had talked about it before we proposed it to DLCD, and then we sent off that notice to DLCD and followed up with public notice along with our other amendments that we did this past year. And that was in June, I believe.
June or July.
And so then we opened the public hearing and then tabled it, and we continued to table it and, or continue it, And once we got going on it and started our discussion, then we've just been continuing it because it hasn't
Well,
been as
I mean,
apparent what to
We've had a
do.
recommendation from the city attorney that the way to proceed is to recommend denial to the council with the statement, as the thing has evolved, many questions have come up, and we think it would be better served to, push this can down the road for a bit, renotice later on in the summer, along with some other comprehensive changes. That way, we're conforming, again, with the code. We can't be accused of just continuing to kick the can down the road.
Right.
If anybody ever were to bring the issue up, we can say that we did have closure. And it doesn't preclude then staff from adding in what those concerns are to city council. You know, we might find the city council says, fine, we just like it the way it is, go ahead and do it. We're not the legislative body, all we're doing is recommending. But in this case, you know, I think it would be legitimate to recommend denial based upon the current questions in the current form.
Well, I think Richard was telling us that we should
Recommend.
make a recommendation, one way or the
Yeah.
other.
This similar, not anything remotely in facts the same, but procedurally similar to what we just did, is to clarity purposes. Denial, let city council then take it. And if they want it, if they like it in the form it's being proposed now, they're going to approve it.
And if-
then we're, you know.
And if they don't, and if they agree with our denial, they agree with our denial for the reasons that are contained in the staff report. And then it's clear, then it loops back around, and we deal with all the rest of the issues. So, does anyone feel like making a motion?
Do we need to do it by number here? I don't have the number in front of me if we're.
It's zoning ordinance amendment 2012-03.
So I would recommend then that we deny ordinance number 2012 I think you gave it wrong, 2012-0.
Recommend to city council.
03, that we recommend denial to the city council, the ordinance.
Was there a request of any members of the public wish to come? I realize nobody's.
Are there any members of the public that wish to comment on this matter? Hearing none?
Second.
Jay, would you call the roll, please?
Wait a minute, do you need to close the public hearing first, then?
And also.
Yes, close the public hearing
We were a
first.
procedural mess tonight, I
We
can
are.
say, yes.
That's because of the new chair. Temporary, very temporary chair.
Nothing on you, Mr. Kelly. I'm just saying, in general, we were all over the place tonight, aren't we? Okay.
Well, I think, first of all, to Mr. Kidd's point, we need to close the public hearing. Then we need to have a motion.
Okay, so,
No,
no, we're closing the public, I think, Mr. Kelly, are you proposing we close the public hearing?
Evans,
Mr. Evans, I'm sorry.
yes.
All right, then I will make a motion that we recommend denial to the City Council ordinance number 2012-03.
Second.
All right. Bryson?
Yay.
Williams?
Yes.
Kidd?
Yes.
Evans?
Yes.
Thank you.
Blame me.
No, I'm fine with this. I think that, we have struggled with this quite a while now, and I think it's time for a break.
As the chairman, your last name has changed tonight, as you.
That's it. But I do thank you, Deborah. I know
Thank
it
you.
hasn't been
No, I
easy.
think there was a lot of good work that went into this.
I do, too.
Well, good.
Yes.
So,
I'd ask that you return to the matter of adopting a final order for number 2013-1, which is actually file APP 2012-02, the appeal. You made a tentative oral decision earlier and directed me to return with written findings. We had kind of worked on draft findings using Richard's staff report earlier, so I have two versions of findings for you. One is a more detailed version, one is a more simplified version. I'll tell you that of the two options, I prefer the more detailed version because I think you're more fair to the applicant, letting him know exactly upon which basis the decision made in terms of what staff's analysis was. I realize that some of you don't disagree with all respects of it, and I did make an error. I didn't specify, as I just reviewed in your rules, the basis for Mr. Williams' vote against it has to be briefly expressed on the last page, and I'm not quite sure what to write there, but I did.
Although he ended up voting for it, so, Mr. Williams, yes, okay.
Mr. Kidd did
Yes, right.
change his vote, and I did write that Mr. Kidd expressed that his vote was to achieve final decision so the applicant could exercise his right to appeal. I'm going to hand these out. One, again, was staff's initial draft, and I only added an incorporation of Richard's staff report to that one. And the others was the more detailed version is fleshing out of the issues as I went through earlier. Shorter.
Right, so can you clarify for us here, we have two documents. One is 4 pages long, just to cut it quickly, and one is 6 pages long. You're saying the 6-page document is the more detailed explanation?
Yes, the 6-page document begins simply with a clarification that this is a de novo appeal hearing, and that the original decision was on December 6th, and it was basically a denial of a request for a sign permit. The project information, land use zoning, those matters are consistent in both orders. Testimony presented is consistent in both orders. When you get to the longer version, starting on page 2, it talks about findings of fact. You adopt the following findings of fact, and then beginning on page 3, there's a little bit more detail there, although for the most part, the findings on page 3 of the longer order are extremely consistent with the findings on pages 2 of the shorter, where they really become, and because mostly those are simply background that was in the record. Where you actually have more detail about the facts as applied to the law is on page 4, where it discusses findings applying applicable code criteria. And so there's really no equivalent of that in the shorter order. What the short order does on page 3, number 15, is basically incorporate by reference the findings in Richard Townsend's staff report, specifically referencing those with reference to 090 A, B, and C. What the longer order does is essentially, beginning on page 4, talks about the application of the definition of nonconforming sign, the evidence in the record of noncompliance with current regulations, again referencing 050G, the use is not permitted, and 060, the size is greater than would be allowed. And then at the bottom of page 4, the question of whether or not it was established that the sign lawfully exists. And then I did modify the longer order on page 5, where it says, assuming for the sake of argument that the sign is legally nonconforming or that some estoppel, and I misspelled theory, operates to protect the existing structure, then the analysis of the requested rebuilding of the sign pursuant to 17-72090 is as follows. So again, it's written in the, okay, we get to the point where the question is, the threshold question, is it a legal nonconformity? Assuming that it is, or assuming there's some theory that gets you there, then the analysis of 090 follows. That's A, B, and C. And again, consistent with the staff report in the record, it finds that A, repair is exceeded, that B is not complied with because replacement requires compliance with current regulations, and that C is not complied with, and specifically rejects the offered interpretation of C that was made by the attorney for the applicant. And then finally, the conclusion is essentially the application is denied. In effect, the decision of the director is upheld, and then I note that the vote, and as I stated, I will have to clarify that Mr. Williams believed that this was in fact a legal nonconformity and that the criteria were met, if that's fair to state.
So I'll just read from our rules here that when you're voting on the final order, the vote is not meant to be a second vote on the subject of the hearing. If the final order or the final recommendation accurately reflects the findings of the majority and the decision, commissioners should vote to approve. So pick the version that you are comfortable with, and then you can vote on that, with, if you have changes that you want our city attorney to make.
They have a couple of changes to the longer version. Page 4, paragraph 14, it's Lincoln City Municipal Code, not County Code.
Sorry, we're
Okay.
Lincoln City, okay.
Page 5, you caught the second paragraph, throaty. Theory?
Yes.
The spelling of my name on this page.
Yes. And again, the rules require that I specify the reasons for Mr. Williams' vote against, and
Again, yeah.
and I'll do that.
Motion to, can we get a motion to elect one of these two versions and have our vote on it?
Mr. Chair, I recommend we adopt final order 13-1 as with the and other items.
Is that, for clarity, the longer version of the order, or, yes?
Yes, that is the longer version of the order. So we're made in.
I'll second.
All right. Bryson?
Yes.
Kidd?
Yes.
Yes?
Evans?
Yes.
Okay, the notice of decision, I believe, will be sent out to the applicant tomorrow, and then they'll have their appeal rights specified there. I will make the typographical corrections and come back for the chairman's signature.
All right. Let's see if we can continue on here. Is there any old business?
Can I interrupt just one last thing? I just reviewed your rules over at Ms. Dashiell's station. I could not find anything where you had specified if there's a tie vote that anything different would happen other than the motion fails. So just want to point out that I did check on that.
There's no scheduled old business. Is there any new business scheduled?
Oh, there is not.
All right. Any reports from the Community Development Director?
No, I don't believe so.
City Attorney is shaking his head. Nothing from him. Planning Commissioners.
I'm just curious if we've had anybody apply for the positions here, so we don't run into this tie vote situation.
Yes, we've had 4 applicants, and they have been forwarded to the city council.
Hey.
Okay, any comments from the public on non-agenda items not involving a public hearing? Our next meeting is scheduled for Tuesday, March 19th at 6 p.m. What is on the agenda for that meeting?
Do you know, Kate?
I don't think we have anything in particular scheduled. So,
Is there an overwhelming reason then to have a meeting?
I don't know. You didn't continue anything from tonight, so do you have anything that you're aware of,
If we
Deborah?
don't have anything scheduled, unless you would like to use that time for training or discussion.
No.
No.
I would,
We have a split vote here.
Just offering.
I would make.
I would agree with you.
I would make, that was Mr. Williams that said no, not me, for the record, but I would,
I would agree with Mr. Williams.
do we need to make a motion on that, the motion to
No, I don't think so.
cancel that? Okay.
It's just I will not adjourn until, can I adjourn before we get the order back? I'll just need to hang around.
You did vote on the order,
We've
and
already
so
done
all
it.
we need is your signature, so I think we're okay.
Well, then, the Planning Commission meeting is hereby adjourned.
Thanks for serving tonight.
Thanks for
Thank you
putting
all.
up with me. This was
Rocked.